In this lecture, we shall discuss the structure of the courts in Ghana. We shall discuss the structure of the courts in Ghana. And we shall have this discussion under Ghana legal systems and methods. The structure of the courts in Ghana. Now, we know that as far as the judiciary in Ghana is concerned, we have the courts in Ghana. Now, what is the structure of the courts in Ghana? What is the structure of the courts in Ghana? Now, as far as the structure is concerned, what we shall start with is Article 126 of the 1992 Constitution of Ghana. Article 126 of the 1992 Constitution of Ghana. Now, what does Article 126 of the Constitution of Ghana say? It says as follows, and I quote, "The judiciary shall consist of the Superior Courts of Judicature, comprising the Supreme Court, the Court of Appeal, and the High Courts and Regional Tribunals. Again, the judiciary shall consist of A, the Superior Court of Judicature, comprising the Supreme Court, the Court of Appeal, and the High Court and Regional Tribunals. B, such lower courts or tribunals as Parliament may by law establish." So from Article 126, you realize that the judiciary of Ghana is grouped into the Superior Court of Judicature and also the lower courts or tribunals as Parliament may by law establish. The judiciary of Ghana consists of the Superior Court of Judicature and lower courts or tribunals as Parliament may by law establish. So, the court structure in Ghana is divided into two broad categories. The Superior Court of Judicature on the one hand, and then the lower courts or tribunals as Parliament may by law establish on the other hand. And as far as the Superior Courts are concerned, we have the Supreme Court, the Court of Appeal, and the High Court and Regional Tribunals. Now, let me draw your attention to some important points at this juncture. There are some people who, in mentioning the courts in Ghana, will say the Supreme Court and Appeal Court. Please, there's nothing like the Appeal Court. If you look at the wording of the Constitution, it says the Court of Appeal. Appeal Court is not the same as Court of Appeal. And I say this because Supreme Court, for example, it can be an appeal court. When you appeal from a decision from the Court of Appeal, it goes to the Supreme Court. When it goes there, it means the Supreme Court is exercising appellate jurisdiction. In the same way, the High Court can also be an appellate court. When you have a criminal matter from the District Court and you appeal to the High Court. In that instance, the High Court will be acting as an appellate court. So, never say appeal court, because when you say appeal court, we don't know what you are referring to. It is better you say the Court of Appeal. That is what the Constitution says. So for the Superior Court of Judicature, we have the Supreme Court, we have the Court of Appeal, we have the High Court, and we have regional tribunals. Now, another thing I want you to identify and pay critical attention to is this. The Superior Court of Judicature are established by the Constitution. They are created by the Constitution. It is the 1992 Constitution of Ghana, under its Article 126. That is where you have the various superior courts mentioned: the Supreme Court, the Court of Appeal, the High Court, and regional tribunals. They are created by the Constitution. But when you look at the B, sub-lower courts or tribunals, as Parliament may by law establish, it means that the lower courts are not created by the Constitution. It means the lower courts are created by Parliament. So the lower court you know of, circuit court, district court, nowhere in the Constitution will you see the mention of circuit court, because they are not created by the Constitution. They are rather created by an act of Parliament. That is why Article 126 clause 1b says, such lower courts or tribunals as Parliament may by law establish. And so at this point, I'll read Article 126 once again, that the judiciary shall consist of the Superior Court of Judicature, comprising the Supreme Court, the Court of Appeal, and the High Court and regional tribunals. B. Such lower courts or tribunals as Parliament may by law establish. So if anybody asks you, by our 1992 Constitution, which courts constitute the Superior Court of Judicature? Please, there are four: regional tribunals, the High Court, the Court of Appeal, and the Supreme Court. These ones are the Superior Court of Judicature, and then they are created by the Constitution. If you look at Article 126 clause 2, it says, the Superior Court shall be Superior Court of record, and shall have the power to commit for contempt to themselves. It means that under our 1992 constitutional framework, the Superior Courts are Superior Courts on record, and they shall have the power to commit for themselves contempt. And so remember that the Superior Courts are created by the Constitution, and we are told that the lower courts or tribunals as Parliament may by law establish. So lower courts are not created by the Constitution. They are rather created by Parliament. So how has Parliament created the lower courts in Ghana? You have to look at Section 39 of the Court Act 1993 Act 459. The Court Act 1993 Act 459. This is what Section 39 of the Court Act says about establishment of the lower courts of Ghana. Now, at this point, let me take your mind back to Article 126 clause 2. Article 126 clause 2 is what says such lower court or tribunals as Parliament may by law establish. Now let us see what the Court Act is saying. The Court Act says that pursuant to paragraph B of clause 1 of Article 126 of the Constitution, the following are by this Act established as the lower courts. So you see that Article 126 clause 1b says such lower courts or tribunals as Parliament may by law establish. Now Parliament is using this Court Act to now establish the lower courts. So you see, pursuant to paragraph B of clause 1 of Article 126 of the Constitution, the following are by this Act established as the lower courts: A. Circuit courts. B. District courts. C. Juvenile courts. And D. The National House of Chiefs, Regional House of Chiefs, and every traditional council in respect of the jurisdiction of that house or council to adjudicate over a cause or matter affecting chieftaincy. So Section 39 of the Court Act has established the lower courts, and it identifies them as the circuit courts, district courts, juvenile courts, and the National House of Chiefs, Regional House of Chiefs, and every traditional council in respect of their jurisdiction to adjudicate over a cause or matter affecting chieftaincy. So if we mention lower courts, they are not created by the Constitution. They are rather created by an act of parliament, which is the Court Act 1993, Act 459 in its section 39, where we are told that the lower courts are the circuit courts, the district courts, the juvenile courts, and the National House of Chiefs, Regional House of Chiefs, and every traditional council. Now remember I mentioned that the Superior Courts under Article 126 Clause 2, it says, they shall be superior courts of record, and they shall have the power to commit for themselves contempt. Now, this provision here is very, very important, because it is only the superior courts of record that are given the power to cite people for contempt of court, especially those ones committed ex facie curia. When I say ex facie curia, I mean that out of the face of the court. So, for example, the court grants an order of injunction. Let us say the district court grants an order of injunction. Circuit court grants an order of injunction. And then the person against whom the injunction is granted fails to comply with the injunction and is still building. He is still building in total disregard for the orders of the court that's what to grant the injunction. Now the question is, can you go to the district court and cite that person for contempt? Can you go to the circuit court and cite that person for contempt? Now, if you go according to Article 126 Clause 2, the Constitution tells us that it's the superior courts that are superior courts of record and have the power to commit for themselves contempt. And the point is even made clearer in the case of the Republic versus District Court Grade 1. Dunkwa Ofeng ex parte Owusu, reported in 1991, One Ghana Law Report at page 136 to 139. Republic versus District Court Grade 1, Dunkwa Ofeng ex parte Owusu, reported in 1991, One Ghana Law Report at page 136 to 139. This is what the court said, and I quote, when it came to the consideration of contempt proceedings in the inferior courts, a distinction should be made between contempt committed in the face of the court during court proceedings in facie curia and contempt committed outside courts ex facie curia. The power to commit for contempt committed outside the court never belonged to inferior courts, with the consequence that they could only seek protection from the superior courts in such cases. Hence, an inferior court which attempted to punish for contempt committed out of court was clearly a usurper, trying to clothe itself with the jurisdiction its very nature or origin denied it, or was assuming an authority its very constitution bereft of it. A court was inferior precisely because it had no more jurisdiction than was expressly granted it. In the instant case, since the law was settled that the offense which the applicant was said to have committed, namely violating an order of the district court contained in the judgment was contempt ex parte curiae or curiae, the district court had no jurisdiction over it. In other words, if you commit contempt of court, and this contempt of court was committed out of the face of the court. So, for example, you go and stand on the radio and then you insult the district court. The district court grants an order of injunction. You refuse to obey it. That district court cannot cite you for contempt. You cannot be cited for contempt before that district court because they do not have the power to commit for themselves contempt. What they have the power to do is what the Act of Parliament tells them to do, and that one doesn't include contempt ex parte curiae. And therefore, if you want to cite that person for contempt, you must go to the High Court and cite that person for contempt in the High Court for disobeying the orders of the district court. You go to the High Court and go and commit the contempt proceedings over there. So therefore, the High Court, the Court of Appeal, Supreme Court, they have jurisdiction to entertain applications for contempt. But the lower court, as we've seen in the case of Republic versus District Court Grade 1, Donkwa of Fairness Pateusu, 1991 One Ghana Law Report at page 136 to 139, says that when contempt of court is committed ex parte curiae, the lower courts do not have jurisdiction to entertain it. You see, in this case, they were using the expression inferior court, inferior court. It is because in the old law, we describe them as inferior courts. But now, under Article 126, they are referred to as well lower courts. So we no more have inferior courts in Ghana. What we have is the language used under Article 126 of the Constitution, which says that what lower courts, as Parliament may by law establish. So at this point, let us recap what the structure of the courts in Ghana once again. Article 126 says the judiciary shall consist of A, the Superior Court of Judicature, comprising the Supreme Court, the Court of Appeal, the High Court, and regional tribunals. B, such lower court or tribunals as Parliament may by law establish. So what law has Parliament used to establish the lower courts? We have the Court Act of 1993 as 459, specifically section 39, where we have the circuit courts, district courts, juvenile courts, and the National House of Chiefs, regional House of Chiefs, and every traditional council in respect of the jurisdiction of that House of Council to adjudicate over a cause or matter affecting chieftaincy. So this is the structure of the courts in Ghana. If anybody asks you, what is the structure of the courts in Ghana? They are divided into two broad categories. The Superior Court of Judicature, comprising the Supreme Court, Court of Appeal, High Court, and regional tribunals, and then the Circuit Court, District Courts, Juvenile Courts, National House of Chiefs, Regional House of Chiefs, and every traditional council, in respect of the jurisdiction of that House of Council to adjudicate over a cause or matter affecting chieftaincy. So this is the structure of the courts we have in Ghana. And we see that structure under Article 126 of the 1992 Constitution. Our next lecture shall be a discussion of the jurisdiction of all these courts in Ghana. So that if you say this is the structure, Supreme Court, Court of Appeal, High Court, what is the jurisdiction they all have? This is what shall be the subject matter of our next lecture. But for now, we know the court structure, and that's 126 is that they are grouped into two broad categories: Superior Courts and then the lower courts. This is where we shall bring an end to our lecture, the structure of the courts in Ghana. Thank you.